Do you need a copy of this letter?
I do not, thank you.
Okay. Yes. It's well, yeah, thank you. I think we're good to go. Okay.
And we're good.
We're good?
All right.
Okay. Your Honor, are you ready?
Okay.
Good afternoon, Your Honor. It's Colleen Curtin Gable and Matthews Powers on behalf of the people. We're here today, Your Honor, on the matter of the request for temporary custody of Harvey Weinstein by the Los Angeles County District Attorney's Office pursuant to the interstate agreement on detainers as codified in New York State Criminal Procedure Article 580. I think, Your Honor, initially I would note Mr. Norman Effman is actually present here in court today. Note that the defendant's lawyer in Los Angeles, Mr. Worksman, is on the Skype, and the defendant appears by Skype from the Wendy Correctional Facility. And I believe that's the first order of business that the court addresses is Skype.
There we go. All right, good morning or good afternoon, everyone.
Good afternoon.
Mr. Weinstein, can you see and hear everyone?
I can hear you, yes, Your Honor.
Great, all right. And did you have a chance before we went live here to speak with your attorney about appearing remotely from the Wendy Correctional Facility for this proceeding this afternoon?
Yes, I did.
All right, and do you consent to appearing remotely from the Wendy Correctional Facility for this proceeding this afternoon?
Yes, I do, sir.
All right, and you have a continuing right to speak privately with your attorney at any point during this proceeding. So if you need to do so, please just let me know and we can arrange for that, all right?
Thank you, sir.
Thank you. And Mr. Workman, you're able to hear and see everyone as well?
I am. I cannot see you, Your Honor, but I can see the courtroom and I can see Mr. Weinstein. Thank you.
Thank you. All right. And good afternoon, Mr. Effman.
Your Honor, as the court is well aware, the interstate agreement on detainers is meant to facilitate, in other words, make easier the temporary attendance of individuals to face charges in other states. It is very clear from the statute what is required. Los Angeles County District Attorney's Office has filed paperwork to that end, Form 5, and then the attendant paperwork. The defense challenged that in a writ, saying that it is somehow the paperwork is improper. We submit that it is proper, and quite frankly, that is the issue before the court today. Article 580 also talks specifically about a time frame for any intervention from the governor, and that time has run out. And to date, there has been no intervention or anything from Governor Cuomo that would affect the transfer. There is also an issue of some medical documentation that we received, and I don't know at which point, if at all, we discuss that.
All right. Why don't we wait on that, and
Sure.
I'll turn it over to Mr. Eppen.
Thank you, Your Honor. I will say that appearing virtually does have its advantages, like I can breathe. Okay, so, and I'm fully vaccinated and I'm more than the distance. I'm wondering if I can get permission to remove this item or whether the protocol demands I keep it on.
Unfortunately, it requires that you and I and everyone else keep it on.
Well, okay.
I may feel the same way that you do, but that's.
Yeah, I know, but the restaurants are open in Elmwood Avenue with packed over the weekend. But beyond that, Judge, the Assistant District Attorney is correct why we're here. And, you know, we discussed the medical issue and just some background, which is, I think they are absolutely correct. The issues in this case revolve around what is appropriate under habeas corpus under the interstate agreement. And that is, are we alleging that our client was not in California at the time of the alleged wrongdoing? Are we alleging that it's not him? Or are we alleging that there's the paperwork does not comply, is not sufficient with the statute? And it's the third item that we are addressing, the paperwork itself. With some background information, the reason we are challenging this is not because we don't want to proceed with a trial in California. It's the timing and it's the issues involved. First was the pandemic. I think everybody is aware that Mr. Weinstein is at the Wendy Correctional Facility, and he's serving a 23-year sentence. What people might not be aware of is that the reason he's at Wendy is that it is a regional medical center. So he's being treated in a hospital setting in a maximum security facility. The medical issues were raised earlier, and he's in the middle of treatment right now, Judge. There are two letters that the court is aware of. One from a doctor that worked with Mr. Weinstein recently, private course of treatment, and a letter from Doc saying he can get that treatment anywhere, which is probably true. And we're not challenging that. It's just that the process has started. And we'd like to compliment docs on dealing with an individual who was rather intense on ensuring that his treatment, given Bob's eyesight, was appropriately handled. And to which doctor would be acceptable, and that is happening. The interesting thing.
Excuse me, you just.
I think they answered that.
I don't know if they can mute.
Where the phone is coming from, Judge.
There's other.
think it's from the correctional
Maybe
facility.
how everybody. What's the problem?
All right, that seems better.
Could be some of the media that has a phone going, so.
Yeah, that's the problem.
So Wendy, they just answered it on the wall.
Oh,
Yeah.
you can see better than that. What we were trying to do is not to avoid the trial, but to avoid an unnecessary stay in a jail rather than a prison. I mean, prisons are designed for long-term incarceration. Jails are not. Even LA, whatever the jail facilities are, cannot compare to what a facility is geared up to do for long-term incarceration. And so he's in a situation, he's from docs. They're doing it right. We applaud them. We tried to do something that is happening every day in this courtroom. That is, if LA wants jurisdiction to commence the proceedings, fine. We can do a virtual arraignment. His lawyer's right. We can consent to it. LA would not. We don't anticipate that any trial in LA is going to occur within 4 or 6 months, and he would be sitting in jail rather than a prison. when he is needed in LA. And we would consent to that. So that's the background. But now I'll talk about the law. So this is probably this request for temporary custody I have seen. I've seen more than most on this. And that there were 3 separate accusatory incidents, separate warrants, all relating to the same time period. And to say it's confusing is beyond what that word means. I think if we take a look at what starts this whole process, it's known as the Form 5. It appears in both our papers and the DA's papers. The first one is dated almost a year ago. It's 25/20, and this is the request for temporary custody. It's exhibit 1. Now, if you take a look at the papers in opposition, you'll also see what was filed in April using the same form. Compare the 2 judges. Hold them side by side. You'll see that the only difference is the date, 6/25/20 and 4/22/21. Other than that, they are identical. The importance of this is that this request lists what the charges are. And if you take a look at the charges right in the middle of the document, they are identical. 4. Now, the first accusatory instrument, I think, had 4 charges. The second had 11, and I don't think it was staged. But only 4 are listed on the request. Now, with respect to the papers I received from the DA's office, and just to clarify something, excuse me, I'm having that breathing is somewhat difficult, but I'll make it through. These opposing affidavits, going back to our last appearance, the ADA said, and you're not going to serve them on the 29th day, are you, under writ? Well, I did not. I served it, I think, on the 4th day. The response I got at the very last day that it was supposed to be here, and that is, I received it by mail Monday. There was a copy sent to me, courtesy copy by email, but cyberspace ate it up. I did get a copy in court Monday morning. So that not being a real issue, but just since I have to reply orally, obviously I didn't have any time to reply in writing. What the district attorney is saying to us here is that we're close enough. These papers are close enough. It's almost like ham and eggs and horseshoes. We almost have it right, but they don't have it right. And the importance of the cases I cite deal with the other side of the coin of the interstate agreement. As the DA points out in the affidavit in opposition, these cases deal with an inmate making a request under the same statute to dispose of it while in custody in New York from another jurisdiction. And in each of those cases, while everyone had notice of what the request was, including the state to which the inmate wanted to go, the notice didn't comply. And in each of those cases, the court said, the statute is mandatory. If you don't follow the statute, you don't get the right to the trial you requested. In our case, if you don't follow the statute, the state does not get requests, and that is temporary custody. So that's the significance of those cases. These rules are mandatory. I think it's paragraph 13 of the affidavit in opposition. It alleges that the form that we're talking about lists the charges contained in the most recent accusatory instrument. And it goes on to say that it enumerates the majority of the charges contained. Well, it lists 4. And I think we count the numbers of charges in whatever the last 2 accusatory instruments, there are 11. That's not majority. It's not even close. It's not even hand-grenade time. It is a mandatory requirement, and the statute is clear. We are challenging the paperwork because it's not right. It's wrong. Yes, the inmate is given notice of all the charges because they attach the accusatory instrument. But in the cases cited, the requesting state, or excuse me, the inmate had actually notified the requesting state in writing of his desire to dispose of those cases. But the court said, he didn't do it right. He didn't follow the statute. It doesn't count. Same thing here, Judge. The other side of the coin. I realize it's a legal technicality. It's a legal technicality that is based on due process, on notice, on the constitutional right, and the statute says, and the courts have said, you follow the rules if you want to do it. It's a simple process. I'm not saying LA is lazy, but you can see this. They just copied the form and changed the date. And it's not the same charges. We know that. Judge, the issues before this court relate to, 1, our request that Mr. Weinstein remain where he is to get the treatment he is now getting, and would be ready to go to LA when they are ready to start a voir dire or jury selection. The legal reason that he should not go to LA is that somebody simply fill out the form right. Legal technicality, that's what due process is about, following the rules. They did not. This court should reject the request. Do it right. Thank you, Your Honor.
Thank you.
I think we'll start first with part which I believe set out in paragraph 13, does show that each of the charges is contained in the document as a whole, in the warrant, on the Form 5. It doesn't have to have each count repeated. It has to have the statutes, and that's what's, I think, you know, let's not have papers on that, Your Honor. It's very clear. 2 things. 1, that the cases cited are completely inapposite to the situation we have here. As the court knows that the statute is to be free to effectuate its purpose, and that when you look at the most recent Form 5 and all of the paperwork as a whole, that Los Angeles County absolutely met the requirements of the interstate agreement on detainers. With respect to the medical, I just want to put some things on the record. I would note that we got a letter from an eye doctor who saw this defendant for the first time last Thursday. And that eye doctor here in Western New York was able to review the defendant's records, examine the defendant, and prescribe a course of treatment. A course of treatment that he said the defendant was anxious because he hadn't been able to obtain. And then the defendant rejected the treatment, saying he wasn't psychologically ready for it. I know from personal knowledge an eye injection is not a procedure, but if that is what was giving him anxiety, and it's clear from the letter that we forwarded today to both counsel and the court from Dr. Morley, that numerous attempts were made to find an ophthalmologist that was, quote, acceptable to the defendant, which I think is going above and beyond the call of duty. Every inmate has an absolute right to appropriate treatment when he or she is in custody, but they don't get to pick when and where they get the treatment. And there's absolutely nothing in either doctor's report that says that this treatment can't be done in Los Angeles. It's Los Angeles. It's not some remote outpost that doesn't have any sort of medical care. Los Angeles has some of the best medical care in not only the country, but in the world. So any of the medical issues can certainly be addressed elsewhere. I think with respect to, I'm going to ask Mr. Powers if he has anything to add with respect to the IAD argument. But I think the time has come for this court to make a decision based on the IAD, based on the submissions of both sides. We submit the paperwork is completely proper, and that taken as a whole and given the statute, the purpose behind the statute, and the facts of this case, Los Angeles County doesn't have to agree to this sort of hybrid, he's sort of here and sort of out there. They don't have to agree to that. And quite frankly, the timing of how long something happens once he's out in Los Angeles, that's governed by statute as well. Really, this court's limited determining whether the paperwork is in fact proper when we submit it. And we would rest with that.
Just briefly, if I could.
Certainly.
My paperwork points out that I believe there are 3 warrants, all coming as a result of 3 different accusatory filed, so that New York State prison system automatically files the detainer and the warrant as a result of accusatory instruments being filed. There are still 3 warrants out there, 3 detainers. To say that this is a simple process. It's done in the 50 states and the federal government as well. Rely on this IAD. But whatever it is, you either comply or you don't. It's not, we came real close, and under the totality of the circumstances, this is not the totality of the circumstances situation. This is either the paperwork is right or it's not. And if it's not, then the request for temporary custody should be denied, with every opportunity for them to get it right, even if it takes a 4th time.
It's not just close, Judge. It's on point. And this counsel who had the last appearance is starting off fresh. Even if you just look at the last set of papers, they've done it properly.
Well, I don't see how it's proper. Again, the form that starts it is not, sorry for the noise in the background, I didn't do that, but it's not consistent with what the other documents show are the pending charges. And if they're not consistent, they came not even close, not even halfway.
They're absolutely consistent, Judge.
Thank you. Thank you, everyone. All right, based upon everything that I've read and I've heard, I believe that the have complied. I will respectfully deny your petition, Mr. Effman, and if California doesn't come to pick up Mr. Weinstein within a reasonable period of time, certainly come back to see me, but based on all of the circumstances and, as I say, the paperwork and argument I've heard, I will respectfully deny your request.
But I did have an additional request in my paperwork, and I think the court is aware of it. On a personal level, I am leaving town on Saturday and won't be back until I'll be back on the 25th. But I have asked the court for a 10-day stay so I can continue the process to apply to the appellate division for a stay. This court has the jurisdiction to do that, and it will give me 10 days to get the paperwork done and see if the appellate division would grant a continuous stay pending.
Your Honor, we've reached out preliminarily to California, and it's our understanding that any attempt to bring Mr. Weinstein to California would not happen until the absolute end of this month, and probably more likely in the first half of July. So just as a practical matter, he's probably not going to be gone before counsel has a chance to make his application directly to the appellate division. But for the reasons already stated, we think the petition is merited. So we would ask him to not to stay.
And I would say that, you know, see everything that Mr. Towers has put on the record, I would still ask then that there's no harm then in granting that stay. It's only a 10-day stay, and he says they're not going to pick him up within that time period.
Well, I guess if that's the plan, if something were to happen sooner, you know, that's our standard plan. Can things change? Yes. And we oppose the stay.
All right, I'm going to respectfully deny your request for the stay as well. I think it's more appropriate that you apply to the court department for a stay if they deem it's appropriate. And of course, I defer to them. But at this point, I will respectfully deny your request. Thank you, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
Are we done?
Hi, sir. Did you need to talk to your attorney? I don't want to cut it off if they're not done.
I think you should probably cut it off.
It's probably already done. It's 2:30. Our document is 10 minutes off at 2:40, okay?
Excuse me?
Our document is 2 minutes off at 2:40. 6:15, 21. At 2:40 p.m. So you should be all set.